Hello, so I'm Jesccia Giles. I'm a law lecturer at the Open University. It's an absolute delight to be here with you all. Many of you I know, and some of you I hope to know better. I have absolute pleasure in introducing the two speakers on this next panel, who will speak for half an hour each, and then we will have half an hour of questions, the same format as the morning. So we have Professor Julian Rivers, who is a professor of jurisprudence at Bristol University. I'll just mention one publication for each author. Please do find out all the other amazing works that they have produced over time. So Julian is author of The Law of Organised Religions. We have Kathleen Brady with us as well, who is fellow at the Centre of the Study of Law and Religion at Emory University. She is the author of The Distinctiveness of Religion in American Law, Rethinking Religion Clause Jurisprudence. I would like, if I may briefly, just to say one thing about each speaker in introducing them. So Julian I have known for 25 years, I worked out, and I would like to introduce him as an academically excellent, faithful, kind, critical friend. And I say that because I value that really, really highly as an academic and in the communities that we are in. And he recently read a piece for me, it came back very quickly, and it is now readable, you'll be relieved to hear if you ever have to read it, readable as a result. So I think when you bare your soul to someone, it has to be someone with those credentials. I say that as well because I think the issues we're facing globally in terms of religion, and what I would call a crisis of religion, can only be countered with those sorts of friendships and the collaboration that is dependent on that level of trust that comes from that friendship. So I would like to give you a new phrase today, and that is a Julian friend, if I may. we had a little bit of who could we see who'd done the most reviewing before we started. So Julian has reviewed 102 articles for the Oxford Journal of 182 articles for the Oxford Journal of Law and Religion, whereas I have reviewed 240 case notes. Needless to say, the content of what Julian has reviewed is much more in-depth and higher level than the work I've done. Kathleen, I would like to commend to you as someone undertaking research of vital importance to humanity. And I am not over-exaggerating that. If you look at Pew Research Centre statistics, they tell us that 84% of the global population adhere to a faith. As Professor Trigg explained, religious individuals will tend to follow their faith over and above the law. If we have a situation where at a national and international level, the law creators and adjudicators are ignoring theology, then we have a deep problem. We have a gap between the governing and the governed, and we have a huge global democratic deficit. So I commend Kathleen and her work to you because she works in particular in the area of law and theology and has training from Yale University in that. So Julian, you're going to come and speak to us first.
Well, thank you very much, Jesccia, for your introduction and for mentioning the Oxford Journal of Law and Religion, copies of which are available in the gift shop afterwards. Is religious freedom under threat from British equality laws? One might think that the answer to this question is obvious. Yes. In Percy and Board of National Mission of the Church of Scotland, 2005, the House of Lords decided that the decision of that church to dismiss the Reverend Helen Percy for sexual impropriety was subject to the jurisdiction of the secular courts to consider an allegation of unlawful sex discrimination. We always used to think that the courts of the Church of Scotland were peculiarly free from secular judicial oversight in matters of doctrine, worship, government, and discipline. At the end of 2008, Catholic Care in the Diocese of Leeds ceased to be eligible to place children for adoption because it refused to place children with same-sex couples, a policy which had been made unlawful by the Equality Act Sexual Orientation Regulations 2007. In the JFS case in 2009, the Supreme Court decided that the JFS, formerly the Jews' Free School, had discriminated unlawfully on grounds of race in adopting a matrilineal test of Jewish identity for their pupil selection criteria. In Hall and Bull 2013, the Supreme Court decided that the Christian owners of a bed and breakfast had acted unlawfully in refusing a double-bedded room to a same-sex couple. Last year, the Court of Appeal decided that a Muslim school had acted unlawfully in segregating boy and girl pupils, and in the Asher's Bakery case, the Supreme Court must decide whether the County Court and Court of Appeal in Northern Ireland were correct to find that the bakery acted unlawfully in refusing to decorate a cake with the slogan, "Support Gay Marriage." So, of course, religious freedom is under threat from British equality laws. How could it be any different? Equality law operates by imposing new obligations on those who offer the general public services, goods, as employers or as educators, and inevitably these new legal obligations constrain liberty, the liberty to act in ways which the legislature now considers undesirable. The only conditions under which such laws could not constrain religious liberty would be ones in which either there was no overlap at all between religious activities and the law, or in which religions never adopted criteria which conflict with non-discrimination standards. Now, the former possibility that religions can be confined to a social space which is entirely extra-legal is one which courts flirt with occasionally. The litigation in Caira and Shergill is the most recent example, and it shows rather nicely to what bizarre conclusions such an approach leads. There was a dispute between two factions as to which of them controlled a Sikh temple. The answer turned on the trusts under which the temple was established, and unfortunately those trusts referred to some rather difficult and contested points of Sikh theological doctrine. The judges of the High Court and the Court of Appeal said that the point was so difficult that they were entirely incapable of resolving it, so they refused to decide the case. It took the Supreme Court to restore common sense, legal common sense, that is. A legal system cannot tolerate a situation in which a court of law refuses to say who owns a particular piece of property. A judge simply has to take evidence and do the best he or she can. To deny the overlap between religions and private right, the law, is radically to disempower, we might say to outlaw, religions. And that is not religious liberty. So the only other way of avoiding the conflict with equality is to suppose that religions never discriminate. But they must, at least in respect of religious discrimination. A religious group cannot sustain its identity unless it does so. What would be intolerable behavior on the part of a public administrator is absolutely essential in a ministerial selection board. And of course, religions and religious people discriminate in many other ways as well, such as race, since some religions are ethno-religions, sex, disability, age, and sexuality. And of course, the law recognizes this. All sorts of exceptions have been written into the law which enable religious persons and groups to act in conformity with their religious precepts. And those exceptions work by a number of different technical routes. In some cases, actions which might cause difficulties have simply been taken outside of the scope of the protection of the law. For example, you cannot bring a discrimination claim in respect of the content of a school curriculum. It's just outside the scope of the law. In other situations, there are justifications for what would otherwise be direct discrimination. So there is a right to take action to comply with the doctrines of a religion or with the strongly held convictions of a significant number of the religion's followers. And then sometimes the legislation leaves the balance up to the courts, which is effectively what happens with indirect discrimination. Now, it's worth noting that this, strictly speaking, is not simply a balance between liberty and equality. It is a balance within both liberty and equality. It is undoubtedly a restriction of my liberty when I am told that I cannot exercise discretion over who I allow to stay in my bed and breakfast. But it is also a restriction of my liberty when I am asked intrusive questions by a hotelier about my personal life and turned away when I turn up. It's undoubtedly a restriction on equality when I cannot live easily with my same-sex partner because of social disapproval of my relationship. But it's also a restriction on equality when I cannot live easily with my religion because of legal restrictions on the contexts in which I can live out its precepts. Liberty and equality are alternative perspectives on the same problem. And this becomes quite obvious when litigants use equality laws to achieve the same ends as they might with a liberty right, such as that under Article 9 of the European Convention on Human Rights. So we might think that this is all about getting the balance right. John Whitty already made reference to balance in discussing John Adams in his presentation. There has to be a balance, and we can obviously argue about exactly where the lines are drawn. The litigation I referred to at the start of my paper is the result either of litigants who do not like where the law has drawn the lines, or genuine uncertainty about where the line is in a particular case. It doesn't matter much whether we think of liberty and equality as zero-sum games or whether we think that there is some sort of optimal solution. Ultimately, we are committed to a range of constitutional goods, goods that include liberty, equality, and we might add several others, such as privacy, security, order, welfare, procedural fairness, constitutional goods which we cannot have all of completely. And at the same time, we cannot abandon any of them entirely. So we are left with balancing between a range of partially or incompatible goods, and this balancing must be done whether at legislative or judicial level. Now, framed like this as a problem of balancing competing constitutional goods, there are at least two problems with the current legal arrangements. The first is, and I think Mark Hill has already alluded to this problem, we have inherited a rather wide and rather rigid approach to direct discrimination. When equality laws were first developed in the 1960s and 1970s, they only covered race and sex. The test that was then used was whether a person had drawn a distinction on grounds of race or sex. It was assumed that in the vast majority of the contexts that the law covered, this drawing of a distinction would be wrong, and the law could then specify in advance those rare occasions on which it was not wrong. That there should be legislative interference at all was politically controversial on general anti-regulation grounds, but the moral judgments implicit in the law, where the law drew the lines, were, I think, in general, not that controversial. So male priesthood, for example, was completely outside the scope of the first sex discrimination law in the 1970s because that law did not cover office holders. Priests are typically office holders, not employees, and there was an express exception written into the law just to make sure. A rule that made direct discrimination on grounds of race and sex unlawful, with a few clear statutory exceptions, worked. Since then, not only have the protected characteristics expanded to embrace those which relate more closely to matters of behaviour and lifestyle, the test has also broadened to cover discrimination because of the protected characteristic. This admits much looser forms of connection, the sort of connection, for example, that's at stake in the Asher's Bakery case. Social mores have also changed and become more diverse, more controversial. But the basic structure of the law has not changed. It is still the assumption of the law that we can tell in advance, by way of rule and exception, when direct discrimination is permissible and when it is not. And this means that sometimes you cannot even get to the question of balance, the question of proportionality, because you are simply the wrong side of the bright line established by the law. It's clear that some, at least, of the senior judiciary have felt boxed in by this rigidity in English law. I'm thinking particularly of the current president of the Supreme Court. The other problem with the law concerns the interaction between the equality perspective and the liberty perspective. The logically minded among you will have noticed that if it is correct that what looks like a conflict between liberty and equality is really a conflict within liberty and a conflict within equality, there are always four possible dimensions to the case. But these possible dimensions don't have all the same legal salience. Go back for a moment to Hall and Bull. Hall and Brady allege discrimination because of sexual orientation in the provision of services to the general public. They are legally on very strong ground. They also have a moral liberty right not to be refused admittance to a place generally open to the public. But you will struggle to get that particular liberty right within the scope of any recognized European Convention right or any other human right, so we tend to ignore it and push it to one side. The Bulls, by contrast, have rather clear religious liberty and privacy rights to control entry to their home according to their precepts of conscience. But these are subject to substantive limitations to protect the rights of others. Think of the structure of Article 9 of the European Convention. Given the status of equality rights in primary legislation, the courts would not have been able to do very much anyway, except perhaps to declare incompatibility. The Bulls' equality claim is even weaker. Again, they wouldn't have such a claim against their customers, but only by combining Article 14 in the ambit of Articles 8 and 9 of the European Convention against the law. Stir into that mix the fact that equality legislation is based on EU law, which enjoys supremacy within the United Kingdom for a while, longer anyway, and liberty rights have to ground themselves on the European Convention and its law under the Human Rights Act, which is more abstract, more malleable, and of limited legal effect. My point is that if we consider the problem of religious liberty and equality law as one of a balance of constitutional goods, then the law currently does not leave the judiciary free to achieve such a balance. For various familiar historical reasons to do with the incremental nature of the British Constitution, it has the effect of skewing the balance in favour of some solutions and against others, in favour of certain equality and liberty solutions and against others. I think the judgment in the Ashes Bakery case is going to be interesting for precisely this reason. Will the Supreme Court be able to get beyond the inherent structural skewing of the law to consider the matter from a broader constitutional perspective? So, the problem of religious freedom and equality law is one of a balance between constitutional goods. The law in this country has institutionalized a certain sort of structural imbalance which tends to privilege some dimensions of the problem over others. And we might think that the solution is reasonably straightforward, even if politically unlikely. Some sort of rebalancing which allows more judicial discretion in cases of direct discrimination, and a tougher sort of homegrown Bill of Rights. But if we think that that is all there is to the problem, then I think we are missing the bigger picture. Second half of my presentation. Notice, first of all, that in some cases, the illegality which has emerged is not actually the result of new legislation. The JFS case is the most striking example of this. Once the House of Lords had decided in 1983, note the date, in 1983 in Mandela and Dowell-Lee, that the Race Relations Act 1976 covered ethno-religions such as Sikhism and Judaism, there was a potential problem with any religious test operated by such groups. The JFS, if the Supreme Court are right, had been acting unlawfully for decades, but nobody noticed, or cared, or thought they could do anything about it. Inequality has come to matter more, and that social significance affects litigation and judicial decision-taking as well. Notice, secondly, that in many of the clashes between equality and religious liberty, the equality requirement is not a result of legal obligation. Islington Borough Council were not required by law to dismiss Lillian Liddell as a registrar for refusing to conduct civil partnership ceremonies. They chose to do so in the name of their equality and diversity policy. And the European Court of Human Rights found it was acceptable for the British courts to approve this balance. The Belgian security company G4S were not obliged to prohibit Miss Akbita from wearing an Islamic headscarf. They chose to do so to project an image of corporate neutrality towards their customers. The Grand Chamber of the European Court of Justice last year confirmed that it was legitimate for the company to pursue such a policy so long as they did so consistently. So they did need to offer Miss Akbita work which was not customer-facing, but if that was not possible, corporate neutrality, a version of equality, could win. Legislation and adjudication do not take place in a vacuum. So the question for us is this: what is the vision of equality which is informing social practice and mores, and thus indirectly moulding our law? In Robert Cover's memorable phrase, what is the narrative which is informing this particular nomos? Now, in his recent book, One Another's Equals, Jeremy Waldron points out that although much has been written in recent years about social and economic inequality, very little has been written about basic equality. Quote, "The idea that we humans are fundamentally one another's equals. The Universal Declaration of Human Rights famously asserts we are equal in dignity and rights. But on what basis?" Not only does Jeremy Waldron seek to clarify such a claim, he also explores the possibility that there is a religious, and more specifically a Christian foundation for our commitment to equality. While some theologians have addressed this question by reference to a single property of human beings, so as Nicholas Wolterstorff argues, we are each other's equals in dignity and rights because we are all equally loved by God, others, of course, have identified a foundation in the Imago Dei. But Waldron is admirably comprehensive. Listen to what he says. Instead of just looking for a property or a set of properties whose static possession is supposed to confer sanctity equally on every human person, we should think instead of the importance that attaches to the commonality of human nature, inasmuch as the same story of creation, life, faith, sin, penitence, and redemption is to be told about us all, each and every one of us. Waldron accepts that in a modern society, not everyone will find inspiration in this religious narrative. But contrary to those liberal theorists who would secularize public reason, he defends robustly the right of each of us to give the fullest and most honest explanation in public as to why we hold the fundamental political beliefs we do. As a Christian, believing that we are each other's equals is part of a basic account of all that is. Waldron seems to assume that we can arrive at a common understanding of human equality from a variety of different religious and ideological starting points. In that sense, he shares John Rawls's liberal optimism that reasonable people can converge on an overlapping consensus about the basic principles of justice. And indeed, this may well be true at a high enough level of abstraction. The troubling question is whether our foundations matter in practice. I suspect that Waldron's religious narrative basis for equality might lead us to political and legal conclusions which no longer command universal assent, if they ever did. Where Islam, for example, has been dominant in a tolerant form, the sort of equality it generates looks very different. To the extent that the millet system of the Ottoman Empire represents a classic Islamic response to religious diversity, it displays very distinctive characteristics. Above all, the competence of self-governing communities, defined by reference to religion, was far more extensive. There was a much deeper pluralism here. Islamic law deals with a much wider range of aspects of daily life than does Christian law, such as family, property, and commercial law. It's wider even than the medieval canon law ever was. And the Ottomans expected other religions to follow suit. Such deep pluralism was reinforced by British colonial powers as they came to govern territories with substantial Muslim populations. It's a hallmark of the practices and demands of many British Muslims today. Let's not kid ourselves. It is a type of equality. 10 years ago, Rowan Williams, then Archbishop of Canterbury, made his famous speech floating the possibility that a greater role should be given to Sharia courts within the British legal systems. The fury of the response to that speech was astonishing. Much of it was simply ignorant. What the Archbishop was suggesting was little more than the practice currently adopted by Jewish tribunals. But the response, I think, was not just a matter of ignorance. In more measured tones, Lord Phillips, soon to be first president of the new Supreme Court, reasserted the principle of one law for all, a common law which treats us equally, regardless of our religious differences. Equality before the law, again. But I wonder if some of the hostility to Rowan Williams's suggestion was not a result of the fact that the Islamic conception of equality, that is, equality between deeply plural religious communities, is diametrically opposed to a third and emerging secular conception of equality. I want to call this conception postmodern equality. In his last great work, Justice for Hedgehogs, the legal philosopher Ronald Dworkin sets out a remarkably Nietzschean justification for his liberal politics. Human dignity, he says, should be interpreted in terms of two principles, self-respect and authenticity. Respect for oneself as author of one's own life is what ultimately grounds morality, that is, respect for others. It underlies familiar features of his liberal polity, such as the basic right of all people to equal concern and respect, and the right to ethical independence. I think that Dworkin's anti-foundationalism betrays a certain postmodernization of liberal thought. Freedom of religion means not simply that we have the right to adhere to our religion, rather it means that we are right when we choose our religion. We cannot be wrong, since Dworkin's morals are without metaphysics. The obligation to avoid discrimination is not derived from a given common humanity, for there is no such thing. Rather, our opinions and lifestyles merit mutual respect simply by virtue of the fact that we have made them ours. Such a vision is diametrically opposed to the Islamic idea of a complete community subordinating itself to external laws given by Allah. Its foundation is also very different, I would suggest, from Waldron's common narrative of creation, sin, and redemption. Postmodern equality downplays disagreement. Because we are each self-constructed, we cannot be wrong. Saying that is as meaningless as claiming that a work of modern art is wrong. You might not like it in your own sitting room, but that preference has no purchase on what others might choose. Postmodern equality breaks down the barrier between who a person is and what they believe, what they claim, or what they do. Because it is based on self-creation, identity becomes equated to performance, even self-projection. You are what you do and seem. And so mutual tolerance, which is based on the idea that I can care about you as an individual human person in spite of the fact that I disagree with you or dislike some aspect of you, mutual tolerance collapses. There is no you behind the you I perceive to be cared about. So tolerance has to become inclusivity, which is to say, the uncritical embrace of the self-defined other. Postmodern equality is also socially homogenizing. It sees speech in Foucauldian fashion as an assertion of power, which makes all social concentrations of worldview suspect. They are sites of potential oppression unless they each become fully inclusive in the way I have just defined. And so we end up banning dissenters as microaggressive violators of our safe spaces, or if we can't do that, at least confining them to the narrowest of possible private spheres. In short, postmodern equality is also post-liberal, because it sees freedom of conscience, freedom of expression, and freedom of association as political failures to address the social causes of oppression. Its apparent embrace of diversity is bought at a very high price indeed. And at this point, I don't think we are talking about constitutional balance anymore. So I close with this question. If I'm right that the conception of equality we adopt is affected by our religious or other ideological perspective, and if I am right that that will inevitably affect the law, how, in a diversifying society, are we to build a secure consensus around a program of equal rights? That, I think, is the question. Thank you very much.
I want to begin by thanking Jesccia for a wonderful introduction and for thanking the folks at the McDonald Center for the invitation to be part of this conference and for their wonderful hospitality. There are perhaps few topics that are more timely for scholars of religious liberty in Western democracies than the tension between religious freedom and equality law. In the United States, this tension has become a central feature of our culture wars, as conflicts have proliferated over laws designed to advance gender equality and to eliminate discrimination against LGBT persons. And on each of the battlegrounds of these culture wars, the advancements of policies reflecting new norms regarding family, sexuality, and marriage have been met with calls from religious traditionalists for exemptions from rules that would require them to facilitate or affirm religiously prohibited conduct and relationships. And these efforts have often been met with fierce resistance from those who believe that religious exemptions will harm those that these laws are designed to protect and undermine the advancement of equality for women and LGBT persons in the law, society, and the economy. For example, with the recognition of same-sex marriage, first legislatively and judicially in a number of states, and now as a matter of constitutional right with the Supreme Court's decision in Obergefell versus Hodges, conservative religious believers and proponents of LGBT rights have clashed over religious exemptions from rules that prohibit discrimination on the basis of sexual orientation. At this moment, the most visible of these clashes have involved small businesses that refuse to provide wedding-related services to same-sex couples. Laws in just over 20 states and many more municipalities prohibit discrimination on the basis of sexual orientation in public accommodations, and cases involving florists, wedding photographers, and bakers with religious objections to celebrating same-sex marriages have popped up across the country. While small in number, these cases have received a great deal of media attention, and all eyes now are on the pending Supreme Court case Masterpiece Cake Shop versus Colorado Civil Rights Commission, a case involving a baker from Colorado who refuses to design cakes for same-sex weddings. Other clashes between religious traditionalists and proponents of LGBT rights are less visible, and many involve protections for religious organizations that resist facilitating, recognizing, or affirming same-sex marriage in their ministries and employment relationships and with their properties and facilities. The dozen states that recognize same-sex marriage legislatively prior to the Supreme Court's decision in Obergefell all included limited statutory protections for religious groups from existing or future non-discrimination rules. In most of these states, religious organizations can't be forced to provide goods, services, or accommodations related to the solemnization or celebration of same-sex marriage, or be penalized for failing to do so. Some of these states also included provisions that permit religious organizations to discriminate with respect to services that promote marriage, such as counseling and retreats. A few included protections for religiously affiliated adoption agencies with religious objections to placing children with same-sex couples, at least as long as they don't receive government funds. In recent years, additional states have enacted some of these protections for religious groups, such as protections for religiously affiliated adoption agencies and those providing foster care. And 2 states have actually adopted very substantial protections, but overall, these states have been few in number, and most states have left many conflicts unaddressed. For example, conflicts over employment discrimination rules have occurred at the state and at the federal level. and additional fights over government funding, licensing, and tax exemption loom on the horizon. In the meantime, in many states, efforts to secure greater protections for LGBT persons in housing, employment, and public accommodations have stalled, as LGBT advocates have resisted the religious exemptions that would make these protections palatable to many of their religious constituents. Today's conflicts pitting religious freedom against equality norms are not limited to fights over protections for LGBT persons. Clashes involving religious exemptions from laws and regulations designed to promote reproductive choice have also been framed by the proponents of these laws as battles over equality. The most prominent example is the fight over the contraception mandate under the Affordable Care Act, the signature healthcare law from the Obama administration. Nonprofit and for-profit employers with religious objections to covering some or all contraceptions in their employee health insurance plans fought with the federal government over the application of the mandate and over the sufficiency of the government's accommodation for years before the Trump administration issued new regulations with broad exemptions this past fall. Proponents of the mandate described its benefits in terms of non-discrimination values. The mandate is designed to equalize the costs of health care for men and women, and it promotes gender equality by facilitating childbearing choices that allow women to participate fully in society and the economy. Among church-state scholars in the United States, the deepening tension between the values of religious freedom and non-discrimination has precipitated tectonic shifts in the field, including the realignment of former allies on religious liberty. The entanglement of debates about religious liberty and culture war issues has, to borrow an analogy used by prominent U.S. scholar Douglas Laycock, taken most of the oxygen out of the room, and scholars have tended to line up behind either one or the other of these two values. On the one side, many scholars have elevated the importance of non-discrimination norms. For example, a number of scholars have argued that equal citizenship requires that same-sex couples be treated in the same way as heterosexual couples in public settings, including in both public accommodations run as for-profit businesses, as well as in religious facilities and ministries that are open to the public. Even limited exemptions for a handful of small wedding vendors in circumstances where comparable services are readily available from other providers would undermine the equal membership of LGBT persons within the community, and it would denigrate and demean them. Most of these scholars affirm the importance of religious freedom, but the values served by religious freedom and the harms that religious exemptions address tend to be underexplored, and religious liberty is easily outweighed by non-discrimination norms outside of purely private settings. For a few, though, religion and religious liberty do not simply recede in importance, they become problematic. Religion has been described as a justification for discrimination against LGBT persons or harms to women. Religious exemptions do not simply subordinate LGBT persons. They're motivated by, and here's just a few quotes, impulses of exclusion, religious ire, or distaste for conduct that's integral to the identity of LGBT persons. On the other side are scholars whose focus is on the value of religious liberty. In conflicts over protections for wedding vendors, some of these scholars draw a distinction between invidious status-based discrimination against LGBT persons, which should be prohibited, and the refusal to affirm and celebrate same-sex marriage, which really isn't discrimination at all. For others, the refusal to serve same-sex couples may be discrimination, but the relevant harms are material, and if same-sex couples can readily access comparable services from other providers, claims for exemptions should prevail. To be sure, the refusal to serve same-sex couples can be experienced by these couples as offensive and even humiliating. However, these dignitary harms result from the expression of disagreement, and moral dissent is inevitable in free societies. Dignitary harms may be real, but they can't override religious freedom. For these scholars, non-discrimination values are not unimportant, but they're not implicated in the ways that their opponents suggest, and they must be balanced with religious liberty concerns. In some cases, though, heated rhetoric meets heated rhetoric. To the charge that religion is being used as a justification to discriminate or to harm women, comes the reply that anti-discrimination rules are being invoked to silence dissent and to drive those with traditional views about marriage and family outside of the public realm. As scholars have divided over the values of religious freedom and equality, prior commitments to robust protections for religious freedom have eroded, particularly in the context of religious exemptions. Questions related to religious exemptions have been at the heart of our debates about free exercise for decades. Everyone agrees that the government should not and cannot intentionally burden or suppress religious practice. But what about burdens on religious practice that are the result of neutral, generally applicable laws that aren't aimed at religion? Should we construe the Free Exercise Clause of the First Amendment to our Constitution to require exemptions, and if so, in what circumstances? And apart from what the Constitution requires, how far should legislative and administrative actors go to protect religious believers in conflicts with the state? And are there any limits on what they can do to protect religious exercise? Prior to 1990, the U.S. Supreme Court interpreted the Free Exercise Clause to afford robust protection for religious practice. When a law or regulation places a substantial burden on religious practice, the religious believer is entitled to an exemption unless the government can show that the application of the law to the believer is the least restrictive means of achieving a compelling state interest. When the Supreme Court reversed course in 1990 in the landmark case Employment Division v. Smith and held that in all but a few categories of cases, religious believers are not entitled to exemptions from neutral, generally applicable laws, its decision was met with shock and outrage, including among most church-state scholars. A few years later, a nearly unanimous Congress passed the Religious Freedom Restoration Act to restore the court's pre-1990 rule legislatively. In the years following the Smith decision, scholars began to criticize the court's pre-Smith jurisprudence on a number of grounds, as they questioned the feasibility and administrability of a compelling state interest test and the fairness of special protections for religious but not secular conscience. However, as debates about religious liberty have become embroiled in the culture wars, there have been even bigger shifts. Increasingly, scholars are arguing that the compelling state interest test should be construed as a deferential standard with relatively weak protection for religious exercise. The Supreme Court had, in fact, watered down the compelling state interest test on several occasions prior to its decision in Smith, and lower courts had often done the same. But scholars were generally critical of these decisions. Now, however, many scholars are embracing what was previously considered problematic. And some are also going even further and joining fierce public resistance to the adoption of state-level laws modeled on the Religious Freedom Restoration Act. In another new development, a growing number of scholars are interpreting the Establishment Clause, and sometimes also the Free Exercise Clause, to place substantial limits on what legislatures and administrators can do to protect religious exercise in conflicts with the state. Where religious exemptions or other forms of accommodation place significant costs on third parties, they're constitutionally prohibited. And for many, relevant harms include the type of dignitary harms that scholars have associated with religious exemptions from anti-discrimination rules. Some scholars have also argued that religious exemptions from laws designed to promote reproductive choice can result in impermissible dignitary harms. Anti-discrimination rules have always been viewed by courts as serving weighty government interests, and claims for religious exemptions from the compelling state interest test have always been at their weakest when there are anti-discrimination norms on the other side. That is, perhaps, part of the reason that those pushing back against religious exemptions in culture war contexts have framed the government interests at stake in equality terms whenever they can. But what's different now is that scholars are increasingly advocating new positions that weaken protection for religious liberty for everyone, not just for those engaged in the culture wars. Conflicts between religious freedom and equality norms have had other costs as well. Within the broader culture, these battles have fed the deepening polarization of American politics and society. And this polarization has undermined civic attitudes and commitments essential to democratic self-government. As each side in our public confrontation seems increasingly to be focusing narrowly on their own interests, distrust has deepened and grown. This distrust is self-problematic, has also made religious freedom more vulnerable. While the Trump administration has delivered in a number of ways on campaign promises to conservative Christians to protect religious freedom in its administrative policies, religious freedom seems more partisan than ever. And there's a big risk that today's victories will be short-lived if religious freedom loses its footing among the most basic and cherished of America's political values. How can we change this destructive dynamic? Part of the answer, I think, is for each side in our current conflicts to revisit and reclaim commitments to both robust religious liberty and equality. Scholars who have focused on equality have tended to leave the important benefits of protecting religious liberty underexplored. Religious exemptions have a long history in the United States, and they date back to the Revolutionary era and even further to the colonial period. When 18th century Americans exempted religious pacifists from compulsory military service and permitted Quakers to affirm instead of take oaths, they did so in large part because they respected the capacity of persons to seek the divine and their desire to follow conscience where it leads. At the heart of religious faith is the relationship between persons and the divine. And the long history of religious accommodation in America reflects and accommodates the priority of this relationship in the lives of believers. Today, it's harder for many who don't have deep religious commitments of their own to appreciate the unique importance of religious commitments in the lives of believers, or the value of accommodating practices that are at odds with important public norms, like non-discrimination. But what's not seen directly is perhaps better appreciated indirectly. Another of the reasons behind our tradition of religious accommodation is the recognition that the importance of religious commitments to believers has a unique capacity to destabilize political societies whose laws restrict religious practice. Religious violence in Europe was a near lesson for those in the American founding era. Today, we're learning a similar lesson. Outsiders seem incredulous that conservative religious believers in America could have aligned themselves with Trump. This alliance has saddened me personally, but whatever one thinks about it, it shouldn't surprise us. It demonstrates the power of religious commitments and narratives in the lives of believers, and it teaches us anew that forcing believers to violate their consciences risks provoking resistance, resentment, and division. But America's tradition of religious accommodation also rests on the benefits that religious communities have for the larger society. America's religious traditions have always played a critical role in supporting public virtues essential for self-government, and our religious diversity has helped to shape, challenge, and renew our public values. Some, perhaps many now in America today, may find it hard to see the positive value of religious conservatism for public morality. Of course, America's religious communities include many different forms of faith with different visions for public life, and religious freedom protects them all. But with respect to religious conservatism, We can all now see that none of us benefits in the long run when religious communities are weakened. America's conservative faiths have in fact contributed in important ways to public values that we all share and depend on. But the new mindset of being under existential threat has turned many of their communities inward. And for some, this inward turn has come with a new distrust of the very political traditions that have nourished our freedoms. Those who focus on the importance of equality in our current conflicts also miss the ways in which religious accommodations are themselves a demand of equality. Proponents of LGBT rights and reproductive choice seek more than just a formal equality that applies the same legal rules to persons, to women or LGBT persons as if differences don't matter. For example, the contraceptive mandate provides for cost-free contraceptions for women, but not men, because that's what's necessary to equalize the cost of health care that is necessarily different. In Obergefell, the Supreme Court held that states could not exclude same-sex couples from a relationship that had been traditionally understood to involve the union of a man and a woman. Long-standing legal rules defining marriage in this way didn't discriminate against gay persons on their face, and their purpose has not been to subordinate gays, but the effect of these rules, the court argued, is to deprive those with same-sex attractions from the multifaceted benefits that we now associate with marriage, such as love, companionship, fidelity, security, and family. Religious accommodations function in a similar way. When neutral laws of general applicability impinge on religious practice, their effect is to force believers to violate their faith or penalize them for not doing so. Religious exemptions remove barriers to fuller participation by religious believers in public life. And so it's a mistake to pit religious freedom against equality in our current conflicts. Equal citizenship is on both sides of the balance. Equal citizenship is in fact one of the purposes of religious freedom. Scholars whose focus in today's conflict is on religious freedom tend to leave the value of equality underexplored. These scholars are correct to point out that those seeking religious exemptions in culture war contexts reject invidious status-based discrimination against LGBT persons. No one is arguing that businesses, large or small, should be able to refuse to deal with LGBT persons as a general matter. Nor is anyone disputing the value of gender equality when they seek exemptions from policies designed to promote reproductive choice. Conflicts arise in this context because of differing views about the morality of contraception and abortion. But more can be said. Those faiths that seek religious exemptions in culture war contexts affirm the equality of all persons as a bedrock principle, a principle as important as religious freedom itself. And part of what this equality consists in is a particular understanding of human dignity. To put it in biblical terms, all persons are made in the image of God. To borrow the language of the Second Vatican Council's Declaration on Religious Liberty, humans are created with reason and free will, and they're called to seek truth and to follow it as they come to know it. In religious matters especially, but in other matters too. We are, in short, moral agents, and our dignity requires freedom to make choices, good choices as well as bad ones. To be sure, there are limits on this freedom when its exercise interferes with the rights of others in the public good. However, liberal societies leave ample room for the exercise of moral freedom, and a similar principle informs our public culture. We have moral disagreements and debate with one another about what is right and wrong, and we try to change each other's minds. But when it comes to public commercial life, we generally do not refuse to deal with one another, even when we rub up against conduct that we view as immoral. For example, bakers design cakes for weddings that they view as immoral, including, in many, if not most cases, cakes for same-sex weddings. Not because the immorality doesn't matter, but because this is how we get along in a free society. We make room for each other. So those on the different sides of our current conflicts regarding religious freedom and equality law share a lot in common, and our heated rhetoric obscures points of convergence or potential convergence. Religious traditionalists don't seek a right to discriminate or to use religion to justify harming women. And those who push back against exemptions do not only seek to shut down dissent. When same-sex couples are refused service by wedding vendors, they do experience a type of exclusion that's not typical, and it can be very humiliating. Indeed, our specific disputes are actually quite narrow, and they fall into three categories that all involve matters at the core of religious freedom. One set of disputes over protections for LGBT persons involves small businesses run by individuals with religious objections to affirming or celebrating same-sex marriage. Florists, wedding photographers, and bakers complain about something very specific. They view their particular services as involving a type of engagement and artistry that would affirm the marriage involved, and affirm it in a way that most goods and services do not. And they're making a claim about compelled expression, as the Colorado baker has argued in the Masterpiece Cake Shop case before the Supreme Court now. The second set of disputes involving protections for LGBT persons, religious organizations seek a much broader freedom to structure their ministries and employment relationships in accordance with religious principle. These disputes involve important claims about religious group autonomy. Third, in conflicts over laws designed to promote reproductive choice, individuals, religious groups, and other nonprofit and for-profit entities object to participating in conduct that they view as murder. And a smaller group of entities, mostly religious organizations, also object to facilitating the use of contraceptions in violation of religious principle. Here again, the sticking points involve matters that go to the heart of religious freedom. Just recognizing the narrowness of our conflicts can diffuse tensions and make disputes easier to resolve. But something more is needed. Both sides need to engage with one another in good faith to try to work out compromises that meet each other's most important needs, though not necessarily everything that they want. As our conflicts have become ever more deeply embedded, it may seem Pollyannish to hope for this type of engagement. Hard-nosed realism helps to explain why so many on both sides now seek survival by gaining as much as they can, whenever they can. While some scholars have pointed out that incentives exist for LGBT advocates to exchange religious accommodations for anti-discrimination protections in many states and at the federal level, deep distrust has led to stalemates. In my own work, I've advocated interpretations of our constitutional rules regarding mandatory and permissible accommodations that would push religious believers, government actors, and other government officials and other public actors to work together to try to reach mutually acceptable solutions to conflicts whenever possible. So far, though, these are just ideas in the pages of legal scholarship. However, perhaps more progress can be made if religious leaders take the initiative. In Utah, successful legislative compromise linking substantial protections for LGBT persons and strong protections for religious liberty was jump-started by the Mormon Church. Writing about his role in this process, the majority whip of the Utah State Senate has said that he hasn't changed his views about marriage, family, and sexuality, but he's lived his faith more fully as he came to know and care for those with views that are different from his own and received respect in return. These observations allude to an even more radical, distinctively Christian understanding of human equality, which I believe can help to de-escalate conflict and strengthen our commitment to religious liberty if it's kept in full view. Christianity teaches that our deepest dignity is that we are all sought by a divine love so profound that it suffered the cross. And Christians are called to model and witness to this love in all that they do. For Christians, then, there can be no enemies in the culture wars and our fights over religious liberty. Our opponents are persons to be encountered engaged, and indeed loved. Perhaps the Supreme Court's decision in Masterpiece Cake Shop will also be a catalyst for engagement. It's difficult to predict how the court will decide this case, but a narrow decision in favor of the baker could affirm the values on both sides of our disputes and pave the way for legislative compromises. On the other hand, a more one-sided opinion will make compromise more difficult. We'll know soon enough, as a decision will be coming down before the end of next month.
Thanks so much to both our speakers. I could have gone on listening, but I thought time to give everyone a chance for questions. So, yes, do we want to? There's a question in the front here, and then Ian.
Thank you very much. Just picking up on your last point, you mentioned about the Supreme Court deciding one way. What do you think would be the implications of the Supreme Court deciding the other?
The other way. More fighting. Because the tendency right now, of course, is for you one side gets a victory to kind of go with it, and that's what I'm afraid of. I think if there's a narrow victory for the baker that kind of stakes out some areas related to compelled expression where it makes the most sense to protect religious freedom, and that could sort of pave the way for compromises that would mirror that at the legislative level. But if the baker gets smushed, which actually I fear, then I think there's going to be a lot less potential for that kind of compromise. And there'll be some incentive for LGBT advocates to kind of consolidate gains and keep going. I mean, the battle imagery is actually pretty accurate in what I just see to be going.
Yes, Ian, I just wanted to draw attention to, and then perhaps ask Julian particularly to comment on, a particular type of argument about equality and religious liberty that I don't think was mentioned, but it is nevertheless a very interesting one. This really works on the premise that justice requires not simply that like cases are treated alike, which of course is a foundation stone behind equality and discrimination law, but also that different cases are treated differently. And in European human rights law, we know this principle from a case involving Greece, that it's associated with the Hellenimus, a case under Article 14 of the European Convention. In English law, it's recently been applied just a few weeks ago by the High Court in a decision involving a London coroner who refused to give priority to releasing the bodies to relatives who were Orthodox Jewish or Muslim, and she said that there had to be what she called the Kabrak rule, that all cases were treated the same, regardless of religion. The High Court ruled that she was incorrect, that on occasion, applying this principle, exceptions had to be made, in that case for policy, on grounds of religion. So it's an interesting principle, it has some potential. I wonder if I could just ask you to comment on that, please.
So the Hellenimus case is what is still a fairly rare example. This was a case involving a Jehovah's Witness who had a conviction for refusal to serve in the Greek army, and he was barred from entering, I think, the accountancy profession, if I remember rightly, because of his prior conviction. And the court held that was a violation of his equality right combined with his freedom of conscience right. I suppose in bigger perspective it's part of the European Court's journey towards the recognition of conscientious objection to military service more generally. I think that the thing about, and that's an indirect discrimination case, I mean we call that, I think, in most a neutral rule had been applied to him. No one with a criminal conviction may become an accountant, and it had a particularly burdensome effect on somebody whose criminal conviction was the result not of, dare I say it, evil intent, but of a conscientious stand and refusal to fight in the army. And likewise, the coroner's decision just recently in London is an example of indirect discrimination. So you can see these things from a liberty perspective or an equality perspective. We have there the application of what looks like the rule of equality, of equal treatment, first come, first serve, before the coroner, and it impacts particularly harshly on those whose religious beliefs require them to bury their dead within an exceptionally short period of time after the death, a very short period of time after the death has taken place. I do think that from the perspective of equality, difference of treatment does not carry with it a presumption of justification in the way that same treatment does. So in that sense, I want to defend the distinction between direct and indirect discrimination. I said that I found direct discrimination too rigid. I think it is too rigid because the courts are not left with the freedom to recognise situations which the legislature didn't see in advance as requiring an exception. But in principle, treating everyone according to the same rule has an intrinsic merit. From the perspective of equality, we are all human beings. We have this in common among ourselves. Therefore, we ought to be able to be governed by the same laws, the same rules. And murder is always murder for everyone. We don't have a different law of murder for different people, and so on and so forth. Whereas when it comes to treating different people according to their differences, I don't think it carries that presumptive justification. So there is no presumptive justification about treating a Jewish or Muslim family of a deceased person differently from a Christian or a secular family. It all depends on whether the difference of treatment is proportioned to the difference that you find in the person. So immediately we're in a realm of judgment and discretion of justice, but justice that is sensitive to particularity. And that is a good thing, but it doesn't carry any presumption of justification. So, and I do think we want to hold on to the ideal that we can be governed by similar laws. The Cabaret rule that the coroner adopted is in principle quite an attractive rule because it does try to treat everyone in the same way. It was just blind to a difference that we think, those of us who agree with what the High Court said, and I think the coroner now realises that they were on the wrong side as well, it fails to recognise a difference that is relevant. But there are lots of other differences that would not be relevant to a difference of treatment. So my comment in respect to that is, yes, equality requires the same things to be treated the same way, differences to be treated differently. But if we don't draw a distinction between same treatment and different treatment, we end up going down the line of Peter Weston and saying that equality is a purely empty idea. Because all that equality is, as Aristotle said, treat the same and different differently. Well, that's everything, that's justice. That's not equality anymore, that's just rationality. And I do think equality is a value for the sort of reasons that Jeremy Waldron set out. And if equality is a value, there is a presumptive justification for treating everyone the same way. There is not a presumptive justification for treating people differently.
So 1, 2, 3, 4, 5. Well, you have to remind me what happened to it.
I'm Ryan at ADF. Professor Rivers, I was fascinated by the question you left hanging at the end of your presentation, and I'd ask for some more thoughts on that. With a bit of a nudge in a direction, you talked about how do we protect a sense of equality as a common notion at all going forward, and I'd be interested to hear your thoughts about maybe what we value as a community. So if there isn't a shared sense of human nature or what dignity means in common discourse, maybe there are certain values or ways of living that we want to protect. And I wonder if dialogues like those between Pope Benedict XVI and Julian Habermas, for example, about the necessary conditions for the liberal Western democratic project to flourish might be something of a signpost to where that bridge might be, for example. So if we don't have a shared common notion of human nature, we might have a shared concern to continue this way of life and this way of doing things, which means that certain things have to be in place, like a shared vocabulary, and like a sense of equality for each individual that goes that is beyond something that can be prescribed by others. I wonder if you have any thoughts in that direction.
Julian, so I've accepted 5 questions, we've got 15 minutes. So
The quick answer is, if I had an easy answer to that question, that would have been the paper. It's landed where it landed. Yes, absolutely. I mean, I think that the ideas you're suggesting are really important. I do think we need to keep our eyes on the law, and I don't say that because I'm a lawyer, but because the law represents a relatively philosophically thin point of agreement. So we have to, practically we have to ask, what sort of a regime of rights do we want to live under? And my problem with the way the debate is developing is that partly because certain claims are being articulated through certain legal vehicles, the equality non-discrimination line, when actually they are sorts of liberty claims. I think these are claims for sexual liberty. And they're, in that sense, they're claims which are not very different from the claims that we might make of religious liberty as well. If we can find a way of, and dare I say it, levelling the playing field and then asking the question, what sort of laws do we want to live under? Who is going to control whom here? And how much space are we giving to the individual and to the group and to state and society? That does help us solve some of the problems, simply because of the nature of law as a relatively crude, philosophically thin mode of governance. But underneath it, all those cultural debates have to take place, the sort of ones you identified, and they have to take place on the basis of a willingness to accept and hear the claim of the other and to take them seriously.
So perhaps more debate over the break stuff. Were there any questions for, in the 4 that I accepted, were there any questions for Kathleen? More general questions, yes.
Yes, thank you very much. Hans Roth from Stockholm University. Both very interesting speeches. And my question is mainly to Julian. And you had a very interesting idea about the conflicts within the so-called liberty and equality boxes. And then you used the often used word balancing. And I take the chance now to have a more precise characterization, because often you hear this rhetoric about balancing claims, and it can mean a lot of things. It can mean limiting the scope of one principle, for example, and showing that a putative conflict is not really a conflict at all, and the third meaning could be different forms of compromises. And so if you just want to flesh out that concept in the cases you mentioned here, I would be very grateful.
Very briefly, if you look at David Ross's work, The Right and the Good, a moral intuitionist arguing how we bring together our incompatible moral intuitions, like the obligation to keep a promise and the obligation to not harm when they conflict. He gives an account whereby you have to try to minimise the costs involved to each side of the equation, and actually what he describes as proportionality. It's not called that, but the structure of proportionality in terms of balancing two goods that are hard to compare in various ways is probably a rational minimum, but it leaves a lot of discretion, a lot of openness. I think the big question that we face is actually an institutional one. It's not how does balancing happen, because it has to happen, and it happens more or less by the structure of proportionality, whether you call it that or not. It's who balances. Is it the court who balances? Is it the legislature? Is it the individual? How do we allocate political authority to a balance? That's the big institutional question I think we're struggling with at the moment. That's a slightly sideways answer to your question.
Kathleen, did you want to say anything on balance?
I'll just make an observation. As I was listening to Julian's talk, I thought it was quite fascinating how this just general conflict plays out differently in the U.S. and in Europe. Traditionally, pre-Smith, for example, the balancing of religious liberty versus whatever competing state interests, of course, was very robustly in favor of religious liberty, and that, of course, has changed a lot. But I think that the proportionality, maybe it's heading more in the direction of sort of a proportionality balance. today in America. So what I find is deeply troubling sort of development, sort of the weakening of that strong favoring in favor of religious liberty is something I think is maybe more familiar. I just find it very, very fascinating. And also the other thing that's sort of fascinating in my mind was the ways in which American law prohibits discrimination in certain, discrete settings. Based on certain characteristics, in employment, housing, public accommodations, and so for example, there aren't protections right now for LGBT persons in many states in any of those categories because you have to have those laws in place as opposed to a more general prohibition, and then you sort of carve out religious protections. So I think anti-discrimination law has been maybe somewhat weaker as well in America, at least less broad, which makes these fights in America sort of this battle, but I don't sense it's really, because the sides are maybe more equally balanced. I mean, the sides are powerful. There's power on both sides. I don't know. It's just an impression. I'm just speaking on just listening to Julian's talk.
Thank you. So we've got, was it 3 more questions?
On the issue particularly of small businesses and the issue of equality versus freedom, I think there's a good illustration here about how I think freedom can be indivisible, because it does seem to me that there is such a thing as commercial freedom. Now, I know that's been eroded because of the idea that you shouldn't refuse to serve people because of the colour of their skin or because they're Irish or because of whatever. But at the same time, I do believe that there is such a thing as commercial freedom. I was talking to a hairdresser the other day who just had a woman who came in and said she wanted her hair dyed bright pink. And he said to her, I'm sorry, because he regarded himself as being rather a classic hairdresser, I don't do that kind of thing. I wouldn't do it very well if I tried. I know someone down the road who can do it. Go there. And she did. Now, it struck me that he has a perfect right to do that. He didn't regard himself as competent. I mean, alternatively, he might not have accepted the price that she was offering for it either. So there is an element of negotiation there. Now, the minute that equality overrides all that, and I suppose if the woman said, I'm lesbian, you must do what I say, he would have been in trouble. But I think that the mere fact of commercial freedom there is quite important. And therefore, there are other kinds of freedoms that are also brought in here, I think. I don't know what your views are on that, but do you think that is relevant, particularly in both Britain and America?
Yeah, I don't think that would be problematic in America, because it's not, I mean, whether you want pink hair or not, that desire is not a characteristic that is protected, because we don't sort of attach any sort of sense that you'd be mean, subordinated, disadvantaged in other contexts.
Pinkist.
Yeah.
If I could say it's strictly analogous to the cake case, where they say we're not competent to design a cake for gay couples because we wouldn't do it very well.
I think the competency argument makes sense in terms of counseling, for example. Baking cakes, I think the competency works as well.
It was all about the design of the cake, and they would say we couldn't design it with our hearts in it, and this is an artistic endeavour, which is the argument they use.
So I think there are 2 comments from an English law perspective. One is that we tend to suspect that religion is not commercial, because religion shouldn't, in some sense, be profit-making. And there are certain culturally inflected conceptions of what religion is and isn't, which are at work there. And that's one way we solve problems. We define religion down. So once you're in the commercial sphere, your religious freedom or interest is not as strong. And certainly the European Court of Human Rights takes us down that path as well. But it's also interesting to reflect on the fact that, as Kathleen said, pinkism or whatever it is not protected. So, well, why not? And this is one of the problems I have with equality law generally, is these protected characteristics seem to me hopelessly narrow. I mean, I'm sure they capture certain interest groups who have certain desires to be protected, but if you really, really, really do care about having pink hair, and it needs refreshing on a regular basis, as presumably it does, because it doesn't grow naturally, why should you be allowed to discriminate on those grounds against somebody? What reason lies behind your right to say, I'm not going to support your desire to have pink hair? I do think there are problems about the way in which our equality law has sort of attached to certain dominant interests which have managed to capture a political ambition. And it's not a general equality law. I think general equality laws are much more reasonable. They basically say that you have to have good reason for doing what you do, and you mustn't use an inappropriate characteristic as a reason for denying a service to a person. And that might be that they want pink hair, or it might be that they want something which is associated with a currently protected characteristic. I think there's lots of work to be done on actually what a quality law in a genuine society of liberal equality really looks like.
Thanks, that's a huge debate, I think, the debate. We've got two more, haven't we? Simon and one more. Should we take both questions and then we can use the rest of the time until 2:30 to answer?
Simon Lee from the Open University. Since it's a transatlantic dialogue, I'd like to hear what each of you think the other Supreme Court should decide in these cases. And in particular, and in reference to Professor Trigg's question, there are some differences between these cases. In the Northern Ireland or UK case, there wasn't much designing involved, there wasn't much creativity or great icing work. They were asked to laser print Bert and Ernie from Sesame Street and the slogan, support gay marriage, which they found to be against their conscience as evangelical Christians. Although, as various people pointed out, they made a lot of money out of Halloween cakes. Now, in that case, the Lord Chief Justice of Northern Ireland gave an achingly politically correct judgment, which was then slammed by the leading gay rights campaigner, Peter Tatchell, who was much more liberal and tolerant than perhaps the court had expected. And so I'm interested both in what you think and in what you think is really motivating the judges who seem to be playing to constituencies who actually may have more sophisticated views than the judges think.
Is there one more person I said yes to? Yeah, so I have that question.
Right, thank you for two very interesting papers. My question might be slightly diverging from that, but following up on the question from Professor Rivers about how to decide the balance. I come from Singapore. I'm now a PhD candidate in theology at Durham, but I was a practicing lawyer in Singapore and here in England. And Singapore's been influenced both by American and British legislation and so forth, but has its own autochthonous root, I would say. I'd just like to explore the idea of a rather different legislative framework that Singapore has adopted. And the main thing here is the Maintenance of Religious Harmony Act. And the governing principles there are, number one, clear separation of church and state, that religion and politics must never mix. And number two, harmony between the various religions. And Singapore is very clearly a very religiously pluralistic society, and there's the fundamental principle that you should not cause offense to another religion. So these are like fundamental tenets. And obviously there's a very strong presence of the state in all of this. Singapore is a very paternalistic country for good and for ill. But, you know, to many people on the ground, it may seem to work because it's helped to prevent a lot of religious conflict, inter-religious conflict, which can be very serious in the East. You know, we have a strong Muslim community, there's Hindus, there's Buddhists, there's Christians, there's the humanists as well. So there's the Maintenance of Religious Harmony Act that says, in all that you do, be careful not to cause offense to another religion. And secondly, religion and politics must never mix. So at the end of the day, it means that the state decides what is acceptable.
Do you want to ask the question? Because we're running up against the break. If you answer that, that's great. Has the main continue the debate?
Yeah. Sorry, yes. So to summarize, I'm just wondering what you thought about that as an alternative system, and whether there's something that has to say about who decides the balance and whether that could help. In the process.
So you have 1 minute each.
Very briefly, yes, Singapore, well known for its quite directive approach towards ensuring religious harmony, which I think from a Western liberal perspective perhaps over-suppresses the right to disagree, the right to challenge, the right to be provocative, the right to say things other people don't want to hear because we think they ought to hear them. I suppose my immediate reaction is that's another vision of equality, isn't it? It is another version to put into there are different equality perspectives which one which balance of factors is going to be optimal, that's the sort of question we need to be addressing or answering. So I won't say straightforwardly that's wrong, what's done, that's bad. I think it has costs. Costs to disagreement, to a more agonistic vision of society, but I can see the advantages as well. Do you want to do Ashes and then I'll do Masterpiece?
Well, and so they're actually very different factual cases, and there is one case in the U.S., a Kentucky case, that's more like that Asher's case, and in that case, it's in the Court of Appeals in Kentucky decided. It may go to the Supreme Court and decide in favor of someone who made t-shirts, custom t-shirts in that case, didn't want to make a t-shirt for a gay pride parade. And then in that context, of course, said, well, there really wasn't discrimination based on sexual orientation. The fellow was actually, I don't even think he was gay, though he headed up the group that sponsored the gay pride parade. And then the court also said, well, something that else is happening there is that there you're actually putting the message on the t-shirt, which is very significant in terms of the expressive content. And in several other cases, U.S. cases, have sort of referred to, well, there was another case actually with the Masterpiece Cake Shop case, where in that case someone went in there to get a cake that said something bad about gay, something was abomination or whatever, the baker wouldn't do it, and then the Colorado court said, well, that's okay, that's an offensive message. You don't have to do that. So in America, actually, this is the way I read the cases, dicta, as well as holding, is that the Asher's Bakery has a pretty strong case, but I don't necessarily think it's very strong under the UK law, because I think it's a little bit different, but maybe you could speak to that.
I'm not sure I'm allowed to in this spirit of dialogue. I think where I draw the line is a very, very close and careful question on whether there is a need for personal investment. And it seems to me in a lot of these cases, particularly the wedding cake cases, you've got to look quite critically. Is there really a personal investment here? Are you being asked to do something which actually, like paint a picture which expresses a vision of the good that you find fundamentally abhorrent or obnoxious? And most of these cases, I think, involve simple transmission or non-creative input. And where there's non-creative input, where you're just literally churning out a standard design with some variations, blue, not pink or whatever, then I don't see the case for an exemption. But the moment the individual is required to invest some sort of personal individual creativity, then I think there is a strong case. That's where I want to see the courts, in both cases, drawing the line.
Excellent. Thank you very much. Thank you everyone for taking part in this dialogue.